So this is video 2 of chapter 15, company conclusion and voluntary winding up or liquidation. So the two strains that you need to know about voluntary winding up are members and creditors. Now with members voluntary winding up, the company is solvent, meaning we can pay our debts. With creditors winding up, the company is insolvent, meaning we can't pay our debts. Okay? Now, we're going to look at members first. So under the Companies Act 2006, a company can be wound up voluntarily in one of three circumstances. So remember that companies can be started for a fixed period of time. So say they have a contract for 5 years and that's the whole purpose of their company. When that fixed term ends, the company must be wound up. It can also be wound up in members liquidation and creditors liquidation, and these are the two that we're going to focus on. So members winding up and creditors winding up must be done by way of passing a special resolution, and once this resolution has been passed, it must be sent to the registrar of companies 14 days after that special resolution has been passed. Okay, so voluntary liquidation can be done in three ways. So by the end of fixed term of a company, by members winding up or creditors winding up. So we're going to look at members, specifically. So in order for a members winding up, the company must be solvent. Remember that. Members solvent. Okay, so the company must have made a sworn declaration of solvency no more than 5 weeks before they have the meeting to pass the special resolution. Okay, the declaration must state that they've made a full inquiry into the affairs of the company and they feel that they can pay their debts within 12 months of the winding up of the company. Okay, so they must have a declaration of solvency no more than 5 weeks before their meeting, and that they do feel that they will be able to pay their debts within 12 months of the winding up of the company. Okay? Now that declaration must have attached to it a statement of assets and liabilities. The director, so remember that, this is the declaration continued. It must have a statement of assets and liabilities. Now, directors who bring a member's voluntary winding up must have reasonable grounds. If they don't have reasonable grounds, it is a criminal offense punishable by a fine or imprisonment. Okay, so at the general meeting when they have to pass this special resolution to wind it up, okay? So the members must pass a special resolution in order to wind it up, and it is deemed to have commenced as soon as the special resolution is passed. And at that meeting, they will also appoint a liquidator. Okay? So the declaration then must be with the company registrar within 15 days. That looked like a 2 to me. Within 15 days of the passing of the resolution. Okay? So we're having a meeting. We're passing the special resolution. Once that is passed, we have 15 days to send a copy of that to the registrar of companies. So that is members. That is members winding up. So now we have creditors winding up. Now creditors is different from members in that the company is insolvent. We can't pay our debts. So the company is unable to make a statement of solvency because it is insolvent. Okay? And they must initiate a creditor's voluntary winding up. And in order to do that, the members must pass a special resolution to the effect that the company cannot, by reason of its liabilities, carry on with its business. Okay? Cannot, by reason of its liabilities, carry on with its business. Okay? The company must call a meeting with its creditors within 14 days of passing this special resolution. Okay, so we've called a meeting, we can't pay our debts, we have to let our creditors know within 14 days of passing the special resolution that we're going to wind up. Now notice, to all the creditors of the meeting must be sent to them all, within at least 7 days before that meeting happens. And it must be advertised in 3 newspapers. So the Belfast Telegraph, although your book may say the Gazette, although I don't think that exists anymore, and 2 other local newspapers. So at that meeting, so the creditors' meeting, the directors must present a statement of affairs showing all their assets, their debts, and their liabilities. A liquidator will be appointed and all powers of the directors will cease. So this is at the creditors' meeting. Okay? And that is creditors. So we have members, which is solvent, and creditors, which is insolvent. And in order to effect both of those, you must pass a special resolution. Now let's look at the liquidator. Who is he? So he must be an authorized insolvency practitioner. And his whole role is to effect dissolution of the company. Okay? He must realize the assets of the company, pay off the creditors, and distribute any surplus. Must take custody. Now, the roles, the powers that he has is to take custody of all property of the company and make any persons who is in custody of property, books, anything that he may require of that company to turn them over or transfer them into his authority. Now, the powers that the liquidator has, you would maybe need to know, I would say about 4 or 5 of these. Okay, so power to pay any class of creditors in full, power to pay any or make any compromises or arrangements with creditors, power to execute deeds, power to raise on the security of the assets of the company. You choose whichever ones you think you're going to remember for that, because it will come up, sort of what are the powers of the liquidator. Now, the rules governing repayment of debts. So you do know this one, but this one is the more comprehensive list. Okay, so first and foremost, who gets paid? The liquidator. They absolutely get all of their remuneration and expenses. Then we have fixed charges. Then we have preferential debt, so occupational pension schemes and employment. Then we have debentures, so floating credit or floating charges. Then unsecured creditors, so here's your tax man coming in. Then don't forget about members' dividends that have been declared payable but that haven't been paid yet. They get paid. Then you've got preferential shareholders, and then you've got ordinary shareholders. So try and remember that list. You'll need to know that list. The other thing to point that your book has is a CVA, which is a voluntary arrangement that companies can enter into at any stage with their creditors. And this is essentially a payment plan back. And an administrator can affect this, a liquidator can affect this. And what happens is then you apply to essentially have a moratorium to be protected while you are making these repayments on your plan. And again, so no one can force you into winding up. The company can't go into winding up, and creditors can't bring any legal actions against you while you are protected. Now, once you've made all your payments back on your CVA and the agreement ends, then you're free from that and you go back to trading as usual. The table then for you to look at is the summary table under 15.2.5 company voluntary arrangement. So just have a wee look at that as well. There is a question on Teams now, and it's a past exam question, and also just a quick quiz on there as well. So have that a go.